Mr. Fenwick.
Now, Lord, firstly, homework. To answer Sir Andrew Longmore's point, in relation to Bayern, we've been through both the first instance judgment and the appeal judgment, and we can not see any sign that the point was taken that the remedy was not available after liquidation.
Thank you.
I would submit that that's because it was assumed correctly that it remained available, there being nothing to prevent it being available, no suggestion that it should not be available. The second piece of homework is your Lordship should find before you a blown-up version of the certificate of deposit, which will avoid any issues as to focal. Before I move on to my last few submissions, I'm going to come back, if I may, to the discussion with Lord Briggs and see if I can fluff the lines.
So, having blown the certificate up, what do we collect about the terms of the contract?
You'll see at the bottom left-hand corner, have I got one? That it is, thank you so much, interest to maturity date will accrue at the base rate of 8.875%. The annual yield will be 11.1%. This rate may vary in accordance with the bank's general terms and conditions and applicable deposit terms. And we say that the best evidence we've got of that are the documents which the judge had before him and which I showed to this committee this morning.
So we will pay this certificate to you when you surrender it to us on the maturity date. So that's the obligation of the bank. Is it unqualified?
No, because it's subject to the terms and conditions. And we say that, like so many things about Stanford, on a first and possibly a second view, it looks like they're getting an unqualified promise to pay, but on proper analysis, they're not. So I'm going to come back briefly in, I think, less than 5 minutes to see if I can fluff my lines less badly in dealing with points made by Lord Briggs to me. What we say about the payments are that insofar as there is no absolute contractual right of a Fairfield type, which I'll come to in a moment, then this is unjust enrichment. Insofar as I'm wrong, and there is a contractual right to repayment, then it is a preference. So far as the first is concerned, we have to look at the question of whether there is an absolute promise, bona fide purchaser for value without notice. It's for value that I want to focus on for a moment. In Fairfield, part of the bargain was an express promise to pay as per the NAV as declared from time to time. It was a fixed, firm, and unconditional promise. In this case, it was subject to there being funds available, albeit in the small print, would have been deprecated by Lord Denning, but it's clear if one reads it. And the way I put it is this. In Fairfield, part of the promise, part of the value which had been obtained by the investor when they agreed to invest in the Fairfield fund was a promise that if the fund in good faith declared a NAV, even if mistakenly, they were entitled to be paid, even if it was wrong and there wasn't enough money. In this case, the promise that they received was a promise not to pay them a specified amount on a specified day in all circumstances, but only if and to the extent that there were funds available, with no mechanism for providing them with a safe exit of the kind in Fairfield, no NAV, no taking of account. So what they had agreed to buy was simply a participation in what was available to meet their request to redeem up to the promised maximum amount. And therefore we say that in this case they were not equities, darling, and one looks at all the circumstances for the purpose of the unjust enrichment claim. Now, in Fairfield, there was, of course, no preference claim. The reason for that is perhaps obvious, because in Fairfield, there was accepted as a genuine mistake by the people running the Fairfield Fund as to the true value of their investment in Madoff. They took what Madoff told them at face value and believed that the value of the fund at the date the NAV was declared was as declared. There was therefore no preference of one group of creditors over another. There was no decision to give somebody more than they were entitled to at the expense of the other creditors. At the time they were paid, the belief of those in the fund was that the fund was worth that amount and that there was no preference involved in paying out those who sought to be paid.
Can you just...
By contrast...
Did you want to ask a question?
Well, I'll let Mr. Pennick finish.
I'm nearly finished, and then of course I'm open for business. By contrast, we looked briefly at the Antiguan Companies Act when Ms. Sandels was illuminating the committee. But can we just look again at Volume 2, Tab 20, page 2251. And I can tell the committee that the Companies Act incorporates the same test in it in relation to...
Is this section 44?
Paragraph 44, yes.
Yeah.
Or section 44. So every conveyance, etc., taken or suffered by any person unable to pay his debts as they become due in favour of any creditor, with a view of giving such creditor a preference over the other creditors, whether the giving of such preference is his sole view or one view among others, shall, if bankrupt within 6 months, be deemed fraudulent and void as against the trustee in bankruptcy. That goes through into the Companies Act, same test, and save for the exclusion of the Companies Act in the International Business Corporations Act, would have fed through into the liquidator's powers in the insolvency and liquidation of Stanford Bank. And if we're right that Section 204 is wide enough to include a right to reverse preferences, this is what we will be looking at. And in this case, Fairfield would not be a preference because there's no view to giving those who were paid a preference over others. In Stanford Bank, there is undoubtedly such a preference because Mr. Stanford was prepared with a pot of money which was worth, say, 5 cents in the dollar, to give the creditors who were asking for partial or total redemptions their 20 or 30 or 100 or 120 cents in the dollar, knowing that as a result there would be even less for those who were left behind. So it was a conscious decision to pay out the few at the expense of the many. There may have been various reasons he did it, to hide it in the hope that he could keep going, hope that the crisis would go, but there was nevertheless a knowledge by Stanford and the dishonest directors that what they were doing was diminishing the pot for the many by paying out to the few. So it would fall squarely within Section 44, whereas, of course, that doesn't apply in Fairfield because there was no such knowledge. So that's why we say that if we're right, there was no absolute promise, then it's unjust enrichment. If we're wrong, it's a preference, and as a preference, should be capable of being reversed. And just picking up what Ms. Handels was saying, by comparison with the common law of preference, this kind of provision, which simplifies the task of the court and the liquidator by deeming transfers made in a short period before the act of insolvency or the appointment of the liquidator to be treated as a fraudulent preference, means that one should only have resort to the common law as the very last resort. That's what I was going to say. I think my Lord may have a question.
One final question. I think you've answered half my question. You say if there is a contractual entitlement, you say preference. I entirely understand your analysis of that. But you say by preference, you mean the Section 44 type of preference. Yes. But why should, bearing in mind that the ICBA has not incorporated Section 44, but I think you're agreed falls back on common law preference, why should the court treat it as fair to use a preference test which the liquidators like but hasn't been incorporated in favour of one which you both appear to agree represents the law about this particular liquidation?
If either Section 204 did not exist, or as the learned Chief Justice held we weren't entitled to rely on Section 204, I would be forced back on common law. But what we say...
I'm looking at it entirely within the Section 204 context.
Yes.
Why do you say that it is just as a matter of discretion under Section 204, assuming oppression, to apply one particular statutory preference test which hasn't been incorporated in favour of one which has, namely the common law?
Because the Section 44 represent what I call the modern law on preferences, long codified in statute in this jurisdiction and other jurisdictions, and because in my submission, when somebody has, and this is not the place to deal with the way in which the IBCA, on the consultative committee of which was Sir Alan Stanford, came into being. When you have something which appears to take holus bolus, the Canadian Act, without taking account of the fact that in Canada there is preference legislation which complements it, it is in my submission appropriate to conclude that the wide purposive construction of Section 204 should, in the absence of words making clear that the legislator did not intend there to be a preference or a straightforward preference recourse available, assume that it can. And if you look at Section 204 and the scope of 204, I'm just going to go back to it for, I hope, a last time. We meet the test that it's an act or omission of the corporation business affairs conducted oppressive or unfairly prejudicial to a creditor. The court may make an order to rectify the matters complained of, may make any interim or final order it thinks fit, including without limiting the generality of the foregoing, includes varying or setting aside a transaction or contract. Why should one say that the court, when construing this section, is required to put away the last lengthy period since Lord Masefield was making his comments and force the liquidator to go through the hurdles of common law preference when the wording is perfectly wide enough to include, as part of the test of fairness, the kind of modern approach which is to be found in Section 44. And whether you take Section 44 word for word, or whether you take an approach, and that's why we've said 6 months or such other period as the court thinks appropriate, because the court can, in my submission, under Section 204, use that statutory device liberally interpreted for the purposes of the Act in order to correct what is plainly, in my submission, an unfair preference. And it's either a good argument or a bad argument, but that's the argument. I'm just going to deal in the 12 minutes which remain to me with 2 points. First of all, before the luncheon adjournment, I was making submissions about fairness and about the unfairness of one person getting all their money out in circumstances where somebody else has a loss. And I gave you figures earlier, and this is only in the last very few weeks, it's in the evidence. $102 million not paid during the same period, and in certain cases before requests which were paid, 102 million asked for, 14.8 million paid. So even though that's less than the 1.3 billion, it means that 14.89 million was paid not on a first come, first served, but a who Mr. Stanford fancied basis. And that in itself is evidence of the need to correct, under such rules and guidance as the court may give, the unfairness of the preference. Can I just move next, because it's related to it, to look for a moment at Galantis, which the committee helpfully referred us to, that I think is in your page 2023A, which I assume, because I haven't quite got there yet, is, it must be at the end of, somewhere within volume 1. I don't know what's
Is it in
happening.
volume 1? I mean, I've got it loose because
Yes.
it was Lord Carnworth yesterday who said this could be relevant. And so
Yes.
I think we've all got it loose. Where you've got it, I don't know.
Where it belongs, as far as I can see, is between tab 10 and tab 11. And that's because it is well, it's in alphabetical order.
I mean, is it of any help? I referred to it because I thought it was potentially relevant, although I recognise it on a different point.
It's of some relevance in this sense, that the Act is slightly different. If you go to page 3640 of the report, we'll see that the purpose of the complaint may apply to the court for any order against...
Can you give me the paragraph number?
Yes, it's... I'm trying to... it's still in paragraph 11. The second page of paragraph 11.
Yes.
Can you orientate us, because I'm afraid I haven't read this report, orientate us briefly about the facts, if you'd be so kind.
Yes, it's a Bahamian company where it was found that 2 individuals, whilst directors, had acted in unfair or oppressive conduct. But that conduct was not ongoing, and importantly, at the time the application was made, the company had already been dissolved. And
So who was claiming against whom?
in this particular case, the respondent, who's somebody who had
the creditor against the director
it's a
by
creditor.
using the oppression section.
Yes. The creditor had agreed to sell his shares in a company in exchange for some money, the balance of which was paid by instalment. He wasn't paid. Paragraph 4 says he obtained judgment in February 2005. Then in 2007, the appellants were examined under oath as part of the enforcement. The respondent formed the view the company's failure to pay involved unfair and oppressive conduct on the part of the directors, but by the time he got round to doing something about it in April 2009, the company had been removed from the register a year earlier. Unfortunately for him, he did not make an application to restore the company to the register, whereupon he could have pursued a derivative action or some other claim, but instead asserted that the Act, which is broadly similar but slightly different to the Antiguan Act, still was capable of assisting him.
Thank you.
In this second page of paragraph 11, at the 279 is derivative actions. 280, a complainant may apply to the court for an order against a company or a director, so it's the order is against the company or the director, to restrain oppressive action. So there needs to be a purpose of restraining oppressive action. It also had, if we look over the page at 3641, the same letter H, varying or setting aside a transaction or contract.
Words to restrain oppressive action in subsection 1 are not in the Antiguan Act.
Exactly.
Is that a relevant distinction?
It is a relevant distinction because it was for the purposes of this decision, and there's nobody else to restrain once the company is in liquidation. The important thing is to correct oppressive action which has previously taken place in the form of the preferential payments. Yes. In paragraph 16, there was a suggestion that the conduct still needed to be continuing. The board decided it didn't need to. And then at letter B, the wording of section 280 strongly suggests it's directed at remedying a current oppression or unfair state of affairs. There must be existing oppression or unfairness susceptible of remedy by the court interceding in the affairs of the company. So it must be a subsisting unfairness. 17, order should go no further than is necessary. Yes. All right. Go back again to C. The procedure is made available to restrain oppressive action.
We haven't got things like C. We've just got paragraph numbers.
Paragraph 16.
Yes.
8 lines down.
Yeah.
There must be existing oppression
We've
or
got that.
unfairness.
Yeah.
This is made available to restrain oppressive action in the words of section 281. This is a hook on which the rest of the section hangs. If the condition of subsection 2 are satisfied, the court may make an order to rectify the matter conferred of. The whole section is directed at remedying existing wrongs, and that's the basis on which it failed because the company had been dissolved. But the point that I want to look at here is, first of all, paragraph 29 on page 3647.
We don't have 3647, just paragraph numbers.
I'm so sorry, paragraph 29.
Yes.
In principle, liability in section 272 should be given a broad meaning to achieve its statutory purpose. And then the reference to fairness, which I don't think we need to look at. Over the page of paragraph 37, in the board's view, section 280 confers a remedial discretion of great breadth. A judge acting under this section enjoys a wide discretion, not only as to the content of the remedial order, but also as to the person or persons against whom any such order is made. We're not concerned with discretionary remedy for infringement of an established right, nor is the court declaring a liability. Rather, the exercise of discretion is a precondition to any liability. And Cote G, in the first passage from her judgment in Wilson against Al-Hariri, was correct to characterize this as the court imposing a liability. An exercise of judgment by a court is a precondition of any liability pursuant to section 280. Must be capable of being enforced. And then at 38, the exercise of discretion as to whether to impose a liability is inextricably linked to the particular facts of each case, hence the need to carry out the required assessment on a case-by-case basis. Just as the fairness principle is ultimately unamenable to formulaic exposition, so is the exposure of any given person to the possibility of an order against them, incapable of definition in advance as a liability for this order. And that, in my submission, illustrates why the learned judge at first instance, Justice Rawbank, was wrong to assume that to order anybody to pay back anything in order to assist anybody else who had lost out was against the general and reasonable expectation. The claim failed, as I say, because the company had been dissolved and they didn't apply to restore it to the register, but those dicta are helpful. I just want... What? And that's as ever. Yes, if we go to paragraph 39, the court must be alive to the risk of a complainant seeking an unfair tactical advantage. In an insolvency, this will require an assessment of the competing interests in a particular factual context. The outcome may depend on the number of creditors. So here is the board, the committee of the Privy Council concluding that this remedy in almost identical section is available and can be used and should be used within the context of a liquidation, thus really undermining the learned judge's point. Lords, the last point I'm going to deal with it very briefly and come back to it if necessary in reply, is the question of extirpi causa. We say that the test in Patel and Mirza makes clear that in this case, where there is a distinction between the sole shareholder, Mr. Stanford, and a couple of associates being dishonest, tucked away, pretending to be running the level 3 investments and in fact stealing them, whereas the rest of the directors and employees believed it was a legitimate operation, means that the doctrine of illegality is no longer relevant. But can I just ask you to take up, because it's the shortest way of doing it, Learned Friend's written case at page 1667.
Yes, you are now, of course, eating into your reply time.
I am, and I shall only be eating into it
Yes.
by about 90 seconds.
Very well.
On the liquidator's own case, this is bottom of page 109, SIB engaged in illegal activity.
What page or what paragraph?
Paragraph 109, page
109.
1667.
Very well.
Liquidator's case derived the Ponzi scheme was serious, yes. Investors intended victims, yes. And then F, clear disparity between the culpability of SIB and investors. Investors neither party to nor aware of the illegal activity, benefit consistent with their lawful contractual rights. And then I, conversely, the claim for the benefit of SIB necessarily has to be founded on the SIB's own illegal activity. This is the problem. Here's 109A says the liquidator's claim seeks to return for the benefit of SIB the SIB payments made to investors. I entirely accept that if our aim was to return it for the benefit of SIB and its participants, it would fall foul of the principle. Our purpose is to return it for the benefit of the creditors, and it does not. And in our written case, we refer, and I'm simply going to refer to it, to Montrose, which was a decision where a trustee sought to recover monies paid out in breach of trust. And the example we referred to in our written case, that it would be extraordinary if had the trustees sought to rectify the breach of trust by seeking a declaration for that the shares were held on behalf of the trustees. And would Mr. Upton be entitled to say no claim lies against me because there's been a breach of trust between Iran and Montrose? No ground. And we say there's no ground for saying just because Mr. Stanford was acting dishonestly and in breach of his fiduciary duty for saying that the liquidator cannot recover for the benefit of creditors the sums which have been paid out. That's all I want to say at this stage.
Thank you, Mr. Penny. Well, Ms. Sandels, you've already most helpfully followed in two respects, and we infer that you do not intend to follow again. Thank you very much. So, Professor Watson-Gandy.
My Lord, May it please you, I appear for the amicus. My learned friend suggested that I act for the.
No, you don't.
No, I don't, my lord.
I didn't know, and amicus could even appeal or cross-appeal against a decision that he was unhappy with, but you seem to have managed that.
My lord, it has to be the case.
Yes, very well. Anyway, that's all down the line.
As your lordships have inferred, the nature of the underlying application was of the nature of a BEDU application to seek permission to use the estate of SIB to bring two alternative sets of proceedings. Firstly, one under Section 204, the unfair prejudice application, which is before the court today, and secondly, to seek permission to bring a common law preference claim. That was considered before Mr. Justice Warbank, and I think in paragraph 304, he didn't dismiss that there was a remedy available, but he said that there was no clear-cut prospects of success on the evidence. My lord,
you say paragraph 304?
304. Your lordship will find it in bundle 1, divider 13, page 251 of the record. My learned friend was asked whether the availability of the remedy post-liquidation was debated before either court, and he replied that there was nothing in the bundle. I wouldn't want the impression to be given that the Court of Appeal came to their conclusions in a vacuum, and certainly both Ms. Sandals and Mr. Arthur were questioned at some length by the Court of Appeal on that issue. So yes, there wasn't written submissions, but there was certainly energy and effort expended upon it. My lord, my lord, I don't think I need to deal with the first two grounds, which are the availability to redefine the question before the court, given my learned friend's indication. What I will do instead is turn to the question, my learned friend's first main issue, the pre-liquidation remedy.
The point you took very strongly before the first instance judge, I take it strongly now.
My lord, basically Section 204, what does is it gives a power to rectify oppression or unfair prejudice in the interest of shareholders, creditors, directors, or officers of the corporation. What we say is the purpose, and consistent with that, and indeed with the oppressive, the unfair prejudice and oppressive conduct legislation around the Commonwealth. What this does is it seeks to assist those who are aggrieved against those in power in the corporation. It gives the court a power to step in, to intervene against the company or those in control. Conversely, if you are already in control, the court looks to you to find your own self-help remedies. There's no need in the place of the majority shareholders or the board. And in this case, the liquidator is naturally, given that there is a liquidation, in control of the company. My lord, my lord, Galantis comes into play in these circumstances. Your lordship's been taken to paragraph 16 of the decision in Galantis, and it does merit a quick. I know you've just looked at it. A further quick glance. Yes. Paragraph 16 says however, the wording of the Section 280 strongly suggests it's directed at remedying a current oppressive or unfair state of affairs. This must be existing oppression and unfairness, which is susceptible of remedy by the court interceding in the affairs of the company. And he then goes on to say, the procedure is made available to restrain oppressive action, which in the words of section 281, this is the hook on which the rest of the section hangs. My learned friend quite correctly pointed out that, of course, whilst section 280 closely follows section 204, section 281 doesn't, 204 doesn't have the extra words to restrain.
On the other hand, the opening phrase, before you get to 204 at all, indicating the area of the statute which is effective, does have in capital letters restraining oppression.
Well, that is the first point we made, my lord, because of course that gives the character of the section that follows.
If we have capital letters at the beginning restraining oppression, it doesn't make much difference if you don't have in subsection 1 the words to restrain oppressive action.
Yes.
But we didn't treat that as limiting the remedy, did we, in Galantis?
No, what it does is it gives the character of the proceedings. And indeed, what you then go on to say is, however, the whole section is directed at the existing wrongs, and then you make the point of paragraph 17 that it's consistent with the general line of authorities. Now,
but it does say in 204.2 that you're looking to see whether or not the business or affairs of the corporation is or have been carried on or conducted in a manner which is unfairly prejudicial. So you're looking to the past and seeking to rectify the situation which has resulted from that carrying on of the business.
Lady, the section 204.2, which is largely identical. Let me find the...
Well, we mustn't be taken in by this largely identical, because we are looking at a section which has a unique context in a unique piece of legislation. So we've got to look at it as this section in this Act. Absolutely. Look at it in its context.
However, lady, one is assisted by other sections in other jurisdictions, and since there is a sort of general model that is envisaged by all the legislation that you
Yes, but this is a short form business entity, this international business corporation. And one must assume that the legislature of Antigua and Barbuda intended it to work within the international context and within the offshore business centre of Antigua. And so we have to construe it perhaps with a little bit more liberality than we would a section in the Ontario Business Code and so on. Certainly we have to look at what else is in the Act and what else isn't in the Act.
My lady, I'd agree with that. What we would say is that we also derive from paragraph 22 is of the Galantis judgment is the point which does have commonality with this. It's the section that starts in the present case, however. It is difficult to conclude the oppression was current when the proceedings were commenced. The board's view to suggest that notwithstanding the dissolution of the company, oppression continues in perpetuity until such time as the judgment debt may be paid stretches the concept of oppression too far. This is the counter-argument that's being advanced by Ms. Newman. It's unrealistic to suggest that in the present case that there existed at the time these proceedings were commenced an interest that is presently being oppressed. Furthermore, at the date of the commencement of the proceedings, the company no longer existed and the former directors no longer held office. We would say that in the present case, the effect as regards control is the same. Intervention by the court in the internal affairs of the company was no longer possible. It was not a situation in which the court was able to intercede in the affairs and operation of the corporation and to effectively override the decisions of those charged with the responsibility of corporate governance. What we would say in the similarity in the present case, the decisions Galantis was looking at the decisions with those charged with responsibilities. Here there is no need for the court to override the decisions of those in control because the person in control is the liquidator themselves. The directors no longer have control, or the shareholders no longer have power, and that's by operation of the International Business Corporations Act, Section 305(1), which takes the power away from directors and shareholders and those in control. And here, of course, the liquidator, as we know, is the complainant in this case.
Nevertheless, in Galantis, the point was that the company had been struck off.
My lord, yes. My lord. It's a more extreme scenario.
Why does it follow that we get any help from a case where the company has been struck off to a case where the company is in liquidation? Because although in liquidation, the company still exists, does it not, in the form of liquidators?
What the issue speaks to is the necessity, the need for relief to be given. In Galantis, there was no ongoing need to intercede, to wrest control from the directors, because there was no longer a live company and for which the directors could exercise control. In the present case, there was no need to intercede, not because the company ceased to exist, but because the control of the company had vested on the liquidators.
Professor Watson-Gurney, the ordinary contemplation of the relationship between the English unfair prejudice regime and insolvency is that the reason nobody, so far as I know, has ever brought an unfair prejudice claim while the company is in liquidation is that the liquidator is fully armed. He's an independent professional owing duties to the court and the creditors, and he's fully armed with all the necessary powers to produce a just result in accordance with the statutory scheme. The case being mainly advanced against you, as I see it, is that, unfortunately, for whatever reason, and nobody seems to know why, this ICBA didn't really include a proper statutory scheme to enable the liquidator to achieve those results. What do you say about that?
Well, the answer to that is well,
Okay, well, choose your time.
If I could, the IBCA does have armour which hasn't been drawn to your attention. But what we would say is that cases like Olympia in York, Tobian, Canada, and the Attorney General of Canada, and Five Star Medical, all tend to two issues. One, does the complainant have locus, a sufficient locus, and also to the question of is the person in control. Olympia in York is distinguished by the Court of Appeal because...
Sorry, just before we leave Galantis, paragraph 39, we do seem to have assumed that it would be available in an insolvency. I can't remember how that came up, but in the second sentence of paragraph 39, we talk about an insolvency situation.
Says in an insolvency that this will require an assessment of the competing interests in the particular factual context. The outcome may depend, for example, on the number of creditors, and the court may have to decide whether it is appropriate to allow the remedy against directors under section 280 in favour of one or more creditors, or simply to leave the matter to a pari passu distribution.
Yes, we seem to assume that the mere fact that the company was insolvent or was in an insolvency didn't prevent you using the oppression remedy, which seems to be what the Court of Appeal was saying in the present case. I can see that there's a different argument about whether it's appropriate for the liquidators to be treated as complainants. That's another issue, but it's difficult to say it's incapable of being used in an insolvency. I'm not sure whether you're going that far, are you?
I'm not sure whether Well, let's explore how far the argument can go. Insofar that the remedies are available for pre-liquidation, as you've heard from the Court of Appeal's analysis was to say that this was about putting the company back on a good footing, and the list, since they're all, which would be sort of construed estrum generis on the basis that they are all of a kind. Whilst it's correct, it's not a closed list. The point is that they are all of a kind that one would, which would inform that
Well,
they
with
were.
respect, there's a specific statutory direction to the opposite effect. It says without limiting the generality
Milady, yes.
in 404, so that one should not read in surely a genus in that situation, because Parliament has made it quite clear that one should not.
When a draftsman creates a list, it informs the court that as to the nature of the remedies that are being given. So an example might be sheep, cows, and other the classic example of sheep, cows, and other animals. It doesn't, of course, prevent sort of goats but it might prevent lions and tigers being included.
Far from this case.
Yes, but we've got to take account of the fact that Parliament has said, including without limiting the generality of foregoing. So that the power of the court is only limited by the words in 2042.
Yeah, I think one could. I think there is. I think the intention of Parliament can be construed from that to give a clear message that there is a broad remedy intended and a great deal of flexibility intended, but one still has to construe. But the very fact that the draftsman has given a list of certain kinds informs the court as to the nature of the type of discretion
Well, I think that's,
one has.
yes.
Taking it to a perhaps an absurd end is that one couldn't infer the court should derive from that have powers which were unrelated to the company or.
Well, so let's take a concrete example. Suppose the court decided that in order to give relief, it ought to call a meeting of the preference investors, the ones who are potentially subject to preference claims, and see what their views are on a particular way of distributing the assets. Would that be within the powers of the court?
It's
Not specifically mentioned.
It's not specifically mentioned, but it's of a kind that might.
Yes, indeed. It's a very wide discretion, anyway.
Milady, I wouldn't suggest that it isn't a wide discretion. I think that must be right. But what we would say is that it's not an unfettered discretion, and that one construes how unfettered in the light of the list that's being given.
I still don't think I've got a clear answer to the question, are you submitting that the mere fact that the company is in liquidation means that Section 204 is not available?
That's one of my alternative grounds, yes.
You are? Well, and so how do you reconcile with the fact that in Galantis we seem to have accepted in paragraph 39 that the mere fact of insolvency didn't mean that that provision wasn't available?
Because the answer to that is this. Certainly, in the English courts, the theory of it being available to creditors, to a shareholder with a creditor interest, which is, I think, Tobian and another case which I've handed out, hasn't been discounted. I think it's the very answer that's put to me in relation to Galantis to say, isn't this a country-specific answer?
Is there a possible distinction between a company being insolvent, which might not displace Section 204, or its equivalent in the Bahamas, and a company being in a full-blown liquidation process? I mean, it looks as if the company, although my lord will recall better than me, in Galantis was it went straight from a possibly insolvent but not liquidation status into dissolution. So it never got subjected to a liquidation process. I don't know whether that's right or not.
That certainly would work, because for example...
Yeah, I mean, I don't think we're deciding it, but I mean, anyway, never mind. Your submission is that it's simply not available when the company is in liquidation.
The issue in Taban, the passage in which in Taban that deals with it, would be consistent with that in this respect. The issue there was whether or not there was a sufficiency of interest on the part of the complainant. This was a situation where the company was insolvent. Perhaps I could take you to it. It perhaps makes the point slightly better than I do. The issue is whether there was a sufficiency of interest to bring the claim. You'll find that at First Authority Bundle, Divider 13, page 2026. Paragraph 11, and the passage is, insolvency complicates the unfair prejudice remedy, but the courts take a wide view of prejudice. It says, paragraph 11 says, shares in an insolvent company in liquidation are clearly valueless unless the value of any claims which the company has against the respondents to the petition will eliminate the deficiency and provide a surplus for members.
Sorry, I haven't got the page. Could you?
I'm so sorry, my lady. It's 2026. It's divider 11 of the First Authority Bundle.
Right.
Section 994 of the Companies Act requires the petitioner to show the respondent's wrongful acts have caused him prejudice in his capacity as a member. If the company is insolvent, that means in general the petitioners must show the shares would have had a value, but for the wrongdoing of the respondents. There is a qualification to this requirement. The court has taken a wide view of prejudice suffered by a shareholder, where, for instance, the shares are worthless, but the petitioner has suffered prejudice in some capacity connected with his shareholding, such as that of a lender under a loan agreement made as part of the same investment as the acquisition of shares. Unfair prejudice proceedings may be brought. There are no parallel facts in this case, but the approach in Gamla Staden has an analogue in this case. Gamla Staden serves as a reminder that this court should not erect technical difficulties to prevent Mr. Maidment from obtaining redress if there is sufficient prospect that a potential surplus can at some stage be shown and no unfairness to the other parties is involved. So that would be consistent with that analogy. We do have Gamla Staden, which was I brought in as a loose document at the start of this case. It's a decision of this court. The relevant part of it is page 175 and paragraph 36. Says, in their lordship's opinion, articles 141 and 143, properly construed, do not ipso facto rule out the grant of relief simply on the ground that relief sought not benefit the applicant in his capacity as member. In many cases, such a feature might justifiably lead to the refusal of relief. Ms. Newman suggested in her submissions on behalf of Gamla Staden that Gamla Staden's desire as a member to restore to the company the loss which the director's allegedly negligent management of its affairs had caused was by itself sufficient to justify the grant of the relief sought, regardless of any financial benefit that might accrue to Gamla Staden. She suggested, as their lordships understood it, that Gamla Staden, as a member, had some sort of obligation to the creditors' banks to take steps to pursue the directors for their allegedly negligent breach of their duties to Baltic, and had an interest in preserving its reputation with banks that would be thereby be served. The lordships are unimpressed by that submission. The justification of Gamla Staden seeking Articles 141 and 143 relief must be based on a real financial benefit that Gamla Staden, as an investor via Baltic and SPK, might achieve if the relief sought were to be granted. The lordships do not accept that the benefits must be a benefit to Gamla Staden in its capacity as shareholder, but they do accept that there must, where the only benefit of the application is to obtain payment of a sum of money to Baltic, be some real financial benefit to be derived therefrom by Gamla Staden. So what we derive from that is that Tobias and Gamla Staden show that there must be a sufficiency of an interest to bring a complaint, and there needs to be a personal financial interest. Such a conclusion, we say, is consistent with the Attorney General in Canada case, which you were referred, because there was a cause of action which was the victims, not the companies. Here we've got a situation where we have the liquidator who sits in the shoes of the company, seeking to bring proceedings against certain of the creditors.
The liquidator said he's sitting in the shoes of the other creditors, or you might say all the creditors, but seeking to correct an injustice caused by the fact that some have been paid and others haven't. The unhappiness of that course is that you have the liquidator representing everybody, ostensibly in the liquidation, yeah,
and also being both claimant and defendant.
Well, no, he's got a statutory responsibility, hasn't he, to administer the assets, and he's dealing with one pot of the assets.
Yes, but he stands in the shoes of the company. He doesn't stand in the shoes of the creditors. The creditors may in turn be, in the end, be beneficiaries of his actions. But it's important to draw the distinction between the two roles, particularly in the present case, where the role of the liquidator is effectively at variance with one of the groups that he potentially represents, on his case.
Well, that's why he's seeking the directions of the court.
He's seeking the directions of the court to to use the company's funds to bring effectively controversial relief.
Controversial?
Bring a controversial claim
against them.
Against some of the creditors.
Yes.
Justice Warbank described it as in those terms. I think you'll find the extract at paragraph 253 at page 251 to effectively protect the liquidator from criticism. That's not a nuanced submission because ultimately you can see a situation where whatever route the liquidator takes, there will be one group of creditors who will be disaffected by the decision that he makes.
Yes, but you've got to look at the bigger picture, which is a desire to administer the whole pot of assets available for investors in a way that is fair as between those group of investors who have suffered a common misfortune.
Yes, where are we then, Professor?
Lady, no, I think what I was going to do is to take you on to. Could I quickly take you to Canada and the Attorney General of Canada and then Five Star Medical, just to complete the submission as regards the authorities. that apply in relation to this. Canada Attorney General is 190.8 of the authority bundles, divided as 7.
Yes.
It's very bottom of the page, and it says a trustee in bankruptcy takes the property of a bankrupt as he finds it, subject to statutory provisions such as those dealing with fraudulent preferences and settlements. He only succeeds to the rights of the bankrupt and has no higher or greater rights. Trustee in bankruptcy stands in the shoes of the bankrupt, except where statutory provisions otherwise decree. If the trustee in bankruptcy were permitted to bring the application under section 247, that's the unfair prejudice, it would be attacking the oppressive or as oppressive a transaction which was unanimously approved by the board of the directors of the bankrupt corporation. In argument, Mr. Robertson of counsel for CDIC posed the question, if Trustco were not insolvent, would it have attacked the transaction of oppressive? Clearly, in my opinion, it could not. The remedy given by section 247 of the Business Corporations Act 1982 is a personal remedy. It belongs to the person who has been oppressed by the actions of the corporation or its affiliates. The trustee in bankruptcy, as I said, has no higher rights than the bankrupt corporation, and consequently it cannot bring the application under section 247. The point that we say is being made there is that the liquidator is not in the position that an individual creditor might be. He effectively represents the company as a whole. And what we say derived from Tobiah and Garmleston is that the person who brings the case must be a person whose interest has been prejudicially affected. The liquidator's interest isn't prejudicially affected. The liquidator's interest is only arises, of course, when he is appointed, and then we say that only then he's a person who as a person who's effectively controlling the company. My learned friend has suggested that the liquidator might be described as an officer of the company. It's no doubt common ground between us that a liquidator under the English Companies Act is an officer under English law. What we say is that a liquidator is not an officer under Barbudan or Antiguan law, because an officer under the IBCA is a defined term. And you can see the definition of the term at section 1K of the IBCA, and which you find at divider 5 in the first authorities bundle at 1703. It appears, I'm so sorry, it appears as J. An officer is, in relation to a body corporate, means the chairman, deputy chairman, president, vice president, managing director, general manager, comptroller, secretary or treasurer, or any individual who performs for the body corporate functions similar to those normally performed by a holder of any office specified in 1 or 2. And basically, we would say that means somebody with senior functions that are being delegated by the board.
Remind us, the trial judge held that the applicants were a complainant, not because they were officers or directors, but any other person. Is that right? Did he? Did he? Officers? Shall we ask Mr. Johnson to look into that while you're on your feet?
I'm grateful.
If you'd be so kind.
Yes.
But I mean, does
Thank
it
you.
matter? He certainly decided as a fallback position that they were other persons.
That was
a matter of his discretion, wasn't it?
That's why I hesitate, because
Yes, but I mean, can you challenge that? Are you challenging that?
But insofar, yes.
Why? I mean, he was clearly entitled to decide, assuming that this could apply to a company in liquidation at all, it was surely open to the judge to decide that these were appropriate persons.
We challenged that they were directors, we challenged that they were officers. Insofar that it's not a proper complainant, it's to the extent that it's not appropriate in the context of a liquidation.
Yeah, but I mean, the point about whether they're officers or directors doesn't really matter. It's whether they were other persons, and you say they may have been other persons, but they shouldn't have been allowed to do it in a liquidation. And that brings us back to the same point about the liquidation.
I mean, it's your control point. That this is for people who are not in control, even if they're a director. You wouldn't expect a director who's in control to be able to use the section.
Yes. My Lord, insofar as just for completeness, the different regimes apply to officers and directors as regards as against power to the duties that apply to liquidators. I've set out the different sections in relation to this in my skeleton. They have officers are appointed by the board, where their functions are set by directors. You see that at section 93. They have special duties under section 95. The directors are elected by the shareholders, and that's at 67. Whilst, by contrast, the liquidators appointed by the court at section 306. They have distinct duties under section 307, contrasting the duties of officers and directors at 95. And they have distinct powers under 308. I perhaps should deal very briefly with section 308, because that's a point where I and my learned friend diverge. Section 308 which appears at page 1847.
1847.
Deals with some of the powers of the liquidator. Liquidator may, and your attention has been drawn to, bring, defend, or take part in civil and criminal proceedings in the name and on behalf of the corporation. So basically, the company's he can enforce the company's own claims, So, for example, breaches of fiduciary duty, common law remedies. But he also has powers under 308(3) to summon any person whom the liquidator believes has assets of the company. And then there's a process for examination, and the court's got powers under 308(4) to direct the delivery up of those assets.
So are you saying that a liquidator just has no power to bring an action against the company? As short and simple as that.
The liquidator has power to bring proceedings on behalf of the company.
Yes, but an action for unfair prejudice is always an action against either the company or its directors.
Well, yes, that's what we would say. And there wouldn't be a need to do so, because effectively he's the person in control of the company. He'd be taking proceedings against himself.
So is that a point in aid of your point that it doesn't apply after liquidation, or is it a separate point that even if Section 204 does apply after liquidation, the liquidators can't use it?
It's in aid. It would lead to a circular outcome. In essence, what we say is it cannot be intended the liquidator be a complaint. Because there's distinct there's a distinct regime to allow the liquidator to bring claims on behalf of the company. I ought to also come back on the point as regards the remedies that are available. I'm so sorry, I succeeded in managing to break. I'm so sorry. To come back on certain points as regards it being a pre-liquidation remedy. The first point related to the alternative regimes under Section 301, which is the just and equitable regime, and the unfair prejudice regime under Section 204. In relation to both of those, one of the reliefs that are available are putting the company into liquidation. And in essence, those are the ultimate remedies. We would say both are necessarily, at least in time, pre-liquidation remedies, and that's consistent with the remedies in the list being given to being pre-liquidation relief. The one example that is given of a relief in the list as being a possible post-liquidation remedy is the power to set aside contracts. We would say that relief is unnecessary as a liquidation remedy. And the reason that is the case is it becomes apparent when you turn to Section 304. Section 304, E, F, and E, F, G, H gives, in the court powers in the context of liquidations, an order to determine the validity of a claim made against the corporation, orders restraining the company's directors, B, collecting or receiving any debt or property of the corporation or paying out any property except as permitted by the court, orders determining or enforcing the duty of or liability of present and former directors to the corporation or for an obligation of, and also orders in relation to proving payment satisfaction or compromising claims. What we would say is that all these are reliefs that are available. Now, I need to draw your Lordship's attention to the top of Section 304,
right,
because that says that it's limited to solvent liquidations, and so equivalent to perhaps our members' voluntary liquidation. So keeping that Section 304 in mind, I ask you then to turn back to 288. 2, where we have which deals with the insolvent situation, and you'll be referred to Section 287, whether you have the appointment of a receiver manager. And 288, 2, it says, on an application to the court by a receiver manager of the corporation under this division for the liquidation and dissolution of the corporation, the court has all the powers of the court under Section 304, notwithstanding the corporation is not able to pay or adequately provide for or discharge all of its obligations, but subject to 286 and 289. So we say that there is an alternative relief.
As you pointed out, Mr. Fenwick relies strongly on Section 204, 3H, one of the suggested orders, setting aside a transaction or contract to which a corporation is a party and compensating the corporation or any other party to the transaction or contract. Now, what sort of, on your submission about nothing post-liquidation available here, what sort of scenario is envisaged by this business of an order setting aside a transaction and compensating the corporation.
This allows, your Lordship will see, if you turn in essence, what one might envisage is a situation where a director had transferred assets, or the majority shareholder had transferred assets to themselves, perhaps, and in those circumstances, or perhaps for nominal consideration. And in those circumstances, one can see a situation where the court might wish to reverse the transfer of the business and assets to an associated company connected with the mischievous majority shareholders or directors.
Thank you.
Looking at forgive me, my lord. One of the submissions that is made against me is of course that there is of course section 371 which engages the court in applying a fair, large and liberal construction. What we would say is that whilst we're enjoined to look at this with a fair, large and liberal construction, it isn't necessarily as best suits the liquidator, but as best suits the purposes that are set out in 3712. Your Lordships will find that at page 1878. Those reliefs are, the purposes are set out as the development of a responsible offshore financial trade and business centre, the provision of incentives for foreign business, and basically and thirdly, to enable the citizens of Antigua and Barbuda to share in the ownership and management and rewards of the business activity. What we would suggest is that the liquidator's construction rather disincentivizes, provides a disincentive to foreign business and potentially harmful to Antiguans sharing the benefits of those business activities. In this way, because if there is an element of if the payments can be reopened, investors will be uncertain as to whether they will be able to keep payments that they have received from banks or indeed other companies. And Antiguans doing business, providing supplies, face the risk that their payments may be refunded. In this case, the liquidator is suggesting we limit the relief to the investors. However, the nature of the relief that would be opened up, that doesn't necessarily discriminate against. It would equally be applicable to the person who supplies the milk, the person who supplies services the photocopier or whatever, because they themselves also provide services or goods.
Well, Mr. Fenwick, both in his written case and today, has said you can forget about that wriggle. We're not going for that sort of expenditure.
However, that may be right, but insofar that if he gets the relief that he seeks, he opens the door to those transactions being set aside, because we're looking at a construction of the section in general terms.
As you say, subsection 2 of 371 does focus in all three parts on benefits to Antigua, to the citizens of Antigua. And I wondered whether that was a slight indication that we ought to treat with some respect what the local court of appeal decided in that regard. Yes?
The next issue is whether whether one should construe this in the fact that, on the light of the fact that this would create a new preference remedy, and the fact that there is an existing common law remedy available. We would say that it's significant that Mr. Justice Warburg didn't dismiss that there was a common law remedy available. He just expressed views that it might not succeed on this prospect.
Haven't we been looking at your own case, Professor, before Wallbank J, to the effect that there were two grave difficulties about deploying the common law rules about preference?
My Lord, you have indeed. Part of my brief was to identify generic problems that might arise on a claim. And in the light of that, Mr. Justice Wallbank found that there were no clear-cut prospects of success on that head. But it doesn't mean that preference doesn't exist as a remedy in Antigua and in the common law.
Is there any comparable common law remedy to transactions and undervalue? I'm just trying to think about what aspects of the usual liquidation armory are or aren't there.
Well, the way you would deal with transactions that are undervalue, I imagine, would be by using the remedy to bring a claim for breach of fiduciary duty.
Yes.
And attack it that way. There isn't a statutory provision.
No, but you say it could be attacked by, if you like, suing the directors for breach of fiduciary duty, and then hoping you can make some claim against the recipients on the basis they had notice or something, or that for one reason or other they weren't equities darling.
Yes. The second point, which has been developed in a little to some extent before you, is that is not only the point that one should avoid the duplication of remedies, but also the point that Parliament historically has chosen not to intervene, and you've already had referred to two preference remedies in relation to other statutes, Section 44 of the Bankruptcy Act in respect of individuals, Section 458 of the Companies Act in respect of companies. We would say that omission is deliberate, especially because the IBCAs, at least for some times, had successive amendments in which they were not corrected. However, what we do have now is a situation where there is new legislation which has been brought in to fill the gap. Your Lordships will find that at page A1, sort of the first authority bundle, divider 4. Page 1688, and its title is, it's in the end of the International Banking Act 2016, which is avoidance of pre-receivership transfers.
But this doesn't apply to all ICBAs, does it?
My Lord, significantly not. What it does is it applies only to banks, which are ICBAs. So there's been a deliberate and conscious change, we say, to apply preference legislation to certain international banking corporations, but not to others. So it's not, we would say that it's even further evidence that there is no accident about the process.
What would be the thinking about applying it to banks, but not to other ICBAs?
I'm it'll purely be conjecture on my part, but...
I'm tempted to think this very case. This is 2016?
2016. I suspect my Mr. Lenworth Johnson, who's I'm only a temporary member of the Antigua Bar, but he's a permanent member, who may be able to assist slightly better than I can.
No, I wouldn't say that. One doesn't know. Different type of trust means there just ordinary IBC with part of the Antiguan infrastructure. Ships fly the flag of Antigua. Only just made law dealing with preference, dealing with banks. And I would say that's one of the banks. And
That's what Lord Riggs wondered.
And other banks, because there have been other bank failures in Antigua. But the point is, all through the local personal bankruptcy, for the bankruptcy act. Preference, yes. Preference, but how it means, and they only consider legislation. Other types of IBCs are left.
Yeah, we've got
Other types, so the other species of IBCs which are still made relevant to the common law. So it cannot be accident or design. It is deliberate.
We understand the point. Thank you very much for helping out. Yes, Professor Watson-Gandy.
My lord, what we say is that in those circumstances, but the point doesn't stop there, because of course what's brought in place isn't just a generic open-ended relief. It gives a preference remedy which is restricted to certain specific scenarios. Section 146(1)(a), gratuitous transfers to related parties in the last 3 years, detrimental transactions the last 3 years at B, gratuitous transactions in general gratuitous actions over the last 3 years at C. At F we have something equivalent to our fraudulent our transaction in fraud of creditors. So we have intentional transfers to defeat the liquidation and the creditors. 1 year at G for preference creditors if they're over if they're over £100,000. So small preference transactions escape. And at H, powers to set aside securities entered into the last 6 months. What we don't have is an open-ended relief that's being sought by the liquidators with no time restriction, no issue of fault, and no cap. What we say is all these points tend to lead to is that Section 204 there isn't a need to form a Section 204 because the issue has been overlooked. There's plainly a process taking place with Parliament which has evolved from the common law remedy and certain reliefs in relation to certain people, to more recently to it being extended to banks, but not other IBC, international business corporations. All this tends to show that Section 204 is not considered by the legislature as providing turning on to whether it is available to the second issue, which is whether it is available to non-culpable investors. We differ with the from the liquidators because we interpret the relationship between investors as one of a bona fide purchaser for value without notice. We say the investors are equities darlings. They bought CDs, shows in action, a promissory note to effectively constituting themselves as debtors of the company with a promise to pay either a variable rate of interest or a fixed rate of interest, depending on the product that they bought. In those circumstances, they gave value for their transaction. There's no suggestion that they were on notice. There was no suggestion that they did so in any way culpably. So in those circumstances, that should be treated as bona fide. And in those circumstances, we say have an interest in the loan that they purchased.
Can you just help about the various different terms of these certificates of deposit? The one that's been helpfully blown up for us is one that matured on 31 January 2013. And when you surrender it to us on the maturity date, we'll pay. So that was 5 years.
Yes.
Are there others in relation to which a period of notice is given and then at any time after the expiry of the notice there's a right to repayment? Or are they all fixed term like this?
I understand that they're all fixed term, but there are various terms as regards interest and documents that we've seen so far have related to CDs, so certificates of deposit.
Yes.
We from our side interpret them as effectively a simple loan.
For a period of time?
For a period of time, either on a flexible interest rate or on a fixed interest rate. The significance to the warning as regards changes of interest, we say, is consistent with the fact that some of them are on a flexible interest.
So insofar as some of us were thinking in our mind that you could give X days notice and then get your money back, that was wrong. Well, we must get to the bottom of it.
You can give X days notice and get your money back.
Yes. You pay, I mean, I thought I saw some notes somewhere that talked about giving notice, but you might have to pay an early redemption penalty.
I think that's right.
So it sounds as if there's a right to redeem early, but subject to at a discount.
You suffer.
I can't remember where the note is.
Where do we get that from?
That's from some.
I was looking at...
One, yes, we... Is it? I had it this morning.
Yes, if you look on page 487, they seem to do a flex CD.
Is that flex so far as interest is concerned,
That's
or flex so far as repayment is
Well,
concerned?
it does talk about...
I think we really ought to know by this stage of the long proceeding, Professor, what the various terms of these certificates are. If you don't mind my saying so.
My Lord, yes. At 484, it says you may purchase 3 types of deposit offered by SIBL, CD deposits, each of the minimum amount of $50,000. See section entitled Description of U.S. Accredited Investor CD Program for information regarding CD deposits, including FISC CD, Flex CD, and Index Link CD. We established separate account, CD account, in your name for the maintenance of each of your subscription for a CD deposit. Renewals of the same type of CD will remain in the same account. Each CD deposit will be an account for a maturity you select from a range of maturities we may offer at the time you open the CD deposit. For the fixed CD and flex CD, during the life of the CD deposit, you will receive interest on the principal balance in the CD deposit at the rate for the maturity selected as published at the time of the CD deposit is established. So the answer is the flex CD appears to be a fixed interest rate. We will periodically establish the published rates. At maturity of the CD deposit, we will provide you the principal amount in the CD deposit plus any accrued and unpaid interest. Note, the 5-day notice period required to receive payment, page 6, through the SIBL account. Interest on the CD deposit, if earned, may be paid monthly or accrue to you as we agree at the time of the CD deposit is established. For the index-linked CD, at maturity, we will pay you by credit to your SBIL account the principal plus the greatest of 1, stated interest rate attached at inception, or 2, interest computed at maturity and based on changes in the index you choose at inception.
The next 3 lines.
As described in the section entitled Description of US Accredited Investor CD Program Early Withdrawal Penalty, you may incur substantial penalties, including forfeiture of a portion of your principal sum upon early withdrawal of funds from the CD deposit.
That's what I was thinking of, which rather suggests that at least some of them, but it's probably a particular series, could be withdrawn early at a penalty. And others, it appears, you can roll over after maturity and then you can withdraw on notice.
I think on the face of the document, there's a provision on the where it says this fixed CD, and here, the one I'm looking at, it says USA 60-month USD matures on 31st of January 2013. This certificate matures on the maturity date stated above. It will be automatically renewed for successive terms, each equal to the original, unless the bank is advised otherwise 5 banking days prior to maturity.
There's a bit about early withdrawal on page 6 under Flex CD.
Yeah.
Each CD deposit will be maintained for an agreed period.
Well, it's down the bottom. 4 lines up. Withdrawals of up to, is that 25%, of the principal deposited are allowed without penalties, provided we've been properly notified at least 5 working days in advance. But you can't have more than 4 such withdrawals each year.
Yeah.
So that's it, isn't it, Professor Gandy Watson? Yes. Watson Gandy, sorry.
And there's some more on page 489.
Yes. So to get early withdrawal, you've got to go in for flex CD rather than fixed CD.
Yeah.
I think we've got there. Thank you.
But your main point, because I'm not quite sure I've got your main point here correct, but say if I'm wrong, is that the provisions at page 484 are part of the contract and are contractual obligations. Yes. And whether or not you can withdraw may be a subtext, so to speak, but it's not an essential matter for our determination here, provided that we think that there are contractual obligations.
Yes. It'll affect the amount that you can get out, but it'll affect your title. What we say as regards the warnings that they might not be paid is that they don't amount to a term and they don't exonerate payment. They just alert you to the financial risk. And when one sees sort of similar terms, their financial warnings of a familiar nature, buying investments or seeking investment advice. Your Lordship asked about whether the matter had been considered by Mr. Justice Wallbank at first instance. There are 3 references which I found in his Lordship's judgment, side passages you've been referred to. first appears, I think it's divided 13 of the first bundle, page 245. 245. And the passage states at paragraph 226, however, the joint liquidators take the view that it's not a proper interpretation of events. As the amicus pointed out, under normal principles of banking law, the money paid over to SIB became SIB's monies, and the CD holders, depositors, or account holders, or whatever nomenclature is used, were in reality no more than creditors of SIB. But all they could return their money as creditor. And he said, consequently observe the joint liquidators. This is simply not a case where constructive trust or quis close purpose trust arose. There's nothing to take this case out of the other ordinary relationship of banker and customer. Then at page 255, paragraph 276, Mr. Justice Warbank says, in the present case, the creditors the court is presently concerned with are those who purchased CDs. Under the terms of these CDs, the creditors became contractually entitled to reclaim the amount of the sum they had paid over, for which convenience they can be called to the principal, together with stated amounts of ostensible interest.
So sorry, where are you?
I'm so sorry, my lord. I moved on to page 255.
Sorry, thank you.
Paragraph?
276.
Yeah.
Under the terms of these CDs, the creditors became contractually entitled to reclaim the amount of the sum that they'd paid over, for which, for convenience, can be called the principal, together with the stated amounts of ostensible interest. Upon a strict legal analysis, it appears the depositors were not lending money to SIB, nor were they constituting SIB as trustees of their money. Rather, they were purchasing a prospective entitlement upon terms to repayment of their principal plus interest.
And that, you say that's a correct analysis, do you?
Our understanding is that they're simply debtors.
That's a wrong analysis.
Yeah, we've been looking for what Warbank J said about the terms of the contract, and here it is.
Yeah.
Yes.
We say that there is no unjust enrichment. Your Lordship's, my own friends, in his authorities refers to Lewin, which appears at.
There's a passage in
Gotham.
Fairfield Sentry on this as well, isn't
Yes,
there?
my lord.
Towards the end of Lord Sumption's judgment. Sorry.
I think that's paragraph 18.
Yes, there's rather an arresting paragraph in Mr. Fenwick's case, paragraph 60, if you've got it to hand, Professor Watson-Gandy. Paragraph 60, if you've got it to hand, Professor Watson-Gandy.
I've stolen Mr. Johnson's copy.
Once it's established that assets have been paid out in breach of trust, fiduciary duty, that gives rise to a proprietary remedy in respect of those assets in the hands of those who've received them, provided they can be traced or followed. And that seems pretty clear, but I wondered whether it was entirely accurate, because I wondered whether that proposition would avail the liquidators if they were making claims against what has been called equities darling.
My Lord, the answer to that is, as a general principle, that works, but it's a principle that's subject to certain qualifications. You can see those qualifications even in Lewin, which is in the third authority bundle at page 39.
What page?
Page 2655. It's the final divider, divider 39. You can see in the index of that at page 2657.
I mean, we've got Mr. Fenwick and Ms. Sandels quoting Lewin 41001 and 41011.
Yes.
But I wondered whether
What you don't
they should also have noticed, I may be wrong about this, 41004.
Or 41110, which appears in the index at 2657 under the category when money becomes untraceable, trust money to use to pay debts.
Yeah.
Okay, where are we looking now? I'm looking at an index on page
2657.
2657, but it doesn't have,
And it says 7, under 7 of the index.
yes,
When money becomes the second item under overdrawn bank account
yes,
is trust money to use to pay debts.
yes. And what are we meant to infer about that?
That there is an exception where debts are being paid. One can get the text from Goff and Jones and the law of unjust enrichment in the previous divider, which appears at 2609.
Well, this is I thought we were talking about the proprietary claim. Are we moving on?
Well, it's in relation to the tracing process.
Very well.
It's simply because I don't have that passage in Lewin, and it wasn't reproduced. But I did.
41110, isn't it?
I do have Goff. I do have the principle in Goff and Jones on which perhaps suggests that there might be a similar rule.
So which page?
2609. And it's paragraph 7-69.
Yes, I see.
And it's the rule that the tracing process comes to an end when an asset identified as the substitute is consumed or otherwise destroyed. Generally applies in the case where a defendant uses the money to pay off a debt, for example, by paying the money into an overdrawn bank account. In this case, the creditor is a bona fide purchaser. It would be pointless to follow the money into the creditor's hands. The creditor will have a defence to the claim that might otherwise be brought against him.
And that's both a defence to a personal claim and a proprietary claim. Yes.
I know my little friend cites a number of cases, and just to meet the point, there's an exception to it in respect of cases where established subrogation, which is the next paragraph. But of course, that's something very different from the present facts. Also, it's hoped to refer to a passage in Magani, which you'll find in the first authority bundle, divider 9. At page 1950. And it reads as follows: the basic principle is not in it's paragraph 18 at 1950. The basic principle is not in dispute. The paying money cannot be said to be unjustly enriched if he was entitled to receive the sum paid to him. Or as Professor Byers put in his restatement of English law of unjust enrichment. In general, an enrichment is not unjust if the benefit was owed to the defendant by the claimant under a valid contractual, statutory, or other legal obligation. Therefore, to the extent that a payment made under a mistake discharges a contractual debt of the payee, it cannot be recovered unless, which was not suggested, the mistake is such as to avoid the contract.
Of course, the position is otherwise if it's a preference under legislation which therefore avoids the payment. But you say we're not having to deal with that today because the judge has rejected the common law preference claim.
My understanding of Mr. Fenwick's argument, or the gravamen of Mr. Fenwick's argument, is that this is all very well, but these are matters of defence, which any particular creditor may or may not successfully put up. But as far as bringing a claim is concerned, there's no reason why, if the claim is theoretically available, the liquidator shouldn't be encouraged to bring it.
Well, I think the answer is twofold. Firstly, it's a discretion as to whether to permit the claim. My role was to advance generic defences, which were, and the importance of that is so that a view can be taken as to the prospects of success, which of course would influence the decision as to whether or not the permission is given. Given that we work from a common starting point as regards the statement of facts, that the parties to which I'm supposed to be advancing the case in relation to are parties who effectively are not complicit, not culpable, and not aware of the proceedings. Those would be defences which generically would be available to them. They would be able to say, yes, we would have a defence based upon this. So we would say that the point that Mr. Fenwick makes is wrong, because on the permutation that we're running today, it's something the court could take into account when exercising its discretion.
So do you say none of Mr. Fenwick's proposed claims could succeed?
My Lord, yes, that's obviously it's a different case, kettle of fish, where you're looking at like a claim against Sir Alan Stanford, because
of course
it's out with the character of people that are subject to this appeal. He obviously wouldn't be somebody who was unaware, and certainly couldn't be suggested to be acting.
Was there any appeal to the Court of Appeal against the judge's refusal to give permission to bring a common law preference claim?
No, I think the matter hasn't been pursued.
Yes, where are we then, Mr. Professor Watson-Gandy?
We're on the finishing off. Are we available to to non-culpable investors? The other point that perhaps arises from that, and it's a phrase that which was rather nicely put in Galantis, is that the courts have been careful not to use. In Galantis, it was described as one applies a scalpel, not a battle axe, and it's the courts have been careful not to use this remedy as a means of oppression. And effectively, what we're looking at is a situation where a lot of the respondents, the potential respondents to this case, have put in as effectively their life savings, and where their drawings are out, they've used those drawings. Examples were given in the thing of paying hospital bills and school bills and various things like that. And there's a potential oppression to asking them to disgorge money that have already been spent. One balance that exists in relation to the non-culpable has been seen in a number of authorities where third-party relief against third parties have been granted. and in essence what the courts have referred to have suggested that they'd be available where there's sufficiently implicated in the process as to bring themselves into the same sort of category as the traditional defendants to the unfair prejudice claim. I've got 4 authorities in which I've managed to find where third-party relief was considered. If I could take you very swiftly to them.
Well, there's
it's a minute.
Yeah, well, what would be more convenient from your point of view?
I'm in your lordship's hands. I wouldn't want to.
Well, if you've got 3 or 4 authorities, I think we can't reasonably do that in 2 or 3 minutes. So we might adjourn now. Now, Lady Arden is going now to explain that she would like, and we would all like, the board to be addressed tomorrow morning with a different slant, among other things. Mary.
Thank you. This arises out of Lord Briggs's discussion with Council about the question whether the legal powers and rights given to liquidators can be overridden by use of Section 204 in connection with that part of the landscape in this case. And my request is that you look at a line of authority to see whether there's anything in it that may assist the board. We've had reference to there being a programme of investors and to there being a pot of assets. And I want you to just assume with me for a moment that no one has a legal right to retain the sum he received because there are possible preference or unjust enrichment claims. And the question is whether there are authorities which show that the court could use the common misfortune doctrine. The courts have, from time to time, authorised the distribution of funds to investors where they have suffered a common misfortune on the basis that their strict legal position will not be observed, but distribution will take place on another basis. For instance, the rule in Clayton's case has not been applied where it would be unfair to the body of investors. This line of authority could also have an impact on the ex turpi causa point. The authorities are in part mentioned in a case called Russell Cook Trust and Prentice, Russell RUSSELL-Cook, COOKE, Trust v. Prentice, PRENTIS, which is, to give the neutral citation, is 2002 EWHC 2227, 2002 EWHC 2227 Chancery. But it's also reported in the All England reports and the International Trust and Estates reports. And in that case, Mr. Justice Lindsay refers to some of the earlier authorities. One of them is the decision in Barlow-Clowes in 1992 of the Court of Appeal. But the doctrine goes back a long way, and the question really is whether or not that doctrine would assist the board in any way, and whether it could be stapled on to Section 204 or provide guidance as to how, if a claim can be made under Section 204, it could be used as perhaps guidance to the court as to how to exercise the discretion there given. So it is relevant. It concerns the distribution of the assets of a common fund where there's been a common misfortune. I just wanted to add on Section 204. I note that Parliament, the legislature, has not amended it, but it may be, and this is it's said that that's deliberate, but it may be that Parliament has deliberately not amended it because the section has not yet been authoritatively interpreted, and it may be that if the legislature had made an amendment, it would affect the court's views as to the proper interpretation of the section. And it may be that that's one reason why no change has deliberately been made, at least at the moment. Thank you, President.
So, Professor Watson-Gandy, we're going to look forward to submissions on the common misfortune doctrine, both from you and from Mr. Fenwick tomorrow. But of course, you don't know what the breadth of those submissions is going to be, but I get the impression that you're not likely to use the full hour and a half that is your entitlement tomorrow.
Very good.
You are. So we might mentally expect you to have been finished within about 3/4 of an hour, without binding you to anything.
Subject to common misfortune.
Subject to common misfortune.
Well done. Very well. That's it.